boldip.com.
Good afternoon. Welcome to the Bold Inventor Show. I'm JD Houvener with my co-host Matt Kulseth. Matt, good day.
Hello, hello, hello.
Hello. We're just talking about taking a little break. So I know those rabid listeners were dying, missing those, 3 weeks in a row we took off. We're back today, back in the saddle. Good to have you, Matt. Thank you for being here.
Yeah, likewise. And we were chatting backstage before the pod went live here, and we started talking about updating each other what we're going on. We're like, no, let's just wait. We'll do it on the podcast. So JD, give me the updates, man. You look great. How have you been? You recently went to Scottsdale?
Yeah, we did Scottsdale. Yeah, gosh, Scottsdale. Have you been there recently?
Oh yeah, car shows, man. Car shows.
Yes. Oh, I saw all kinds of. You nailed it. Aston Martin. I mean, Lambos all over.
Peter Jackson's down there. There's some exotic European car show stuff there too. It's cool.
Pretty incredible. A lot of money there in the middle of the desert.
It's weird, isn't it? It's a weird place. Like you said, a lot of money, oasis, middle of the desert.
Yeah,
skyscrapers. And it's weird.
I know, it was fun. We did golf. So we did a combo. My wife and I celebrated 15 years of being married. Wow,
congrats!
It's so cool. We planned this trip. We bought a house, as you know, this year. So we wanted to find a way to celebrate without breaking the bank too bad. So we went to Scottsdale and paired it at the same time as I do a yearly siblings trip. So my brother's sister, both my brother's sister and their spouses, we met at this year in Scottsdale. We did Vegas last year. We rented an Airbnbs, but my wife and I went about 3 days before and just did 3 days on our own.
Nice. I love that. You got the 2 for 1.
2 for 1, for sure. So kids did good. Grandma was here. Everything's intact. No major issues to speak of. So it's really good.
Good.
Yep. Good. Yep. So how about you? Any big updates? Anything going on?
Not too much. Just busy, man. Just busy with work and kids, and been at the fire department a ton. I'm a volunteer firefighter, and we're going through this big transition period right now in our department where we're merging with another department, and it's kind of all hands on deck. So I've been doing a lot more than I normally do. So
same role as a volunteer, or you have to step up and do more.
Yeah, just a lot more like duty crew shifts, like during the day. I don't typically do that kind of stuff. I typically just respond, on call essentially. But no, things are good, man. It's getting cold here in Minnesota.
Oh, I'm sure it's cold at night for sure. Probably below or at freezing.
Yeah. So we got our first frost just a few days ago.
Okay. Yep. I got to winterize my pool. Now that you say that, I know I've been thinking about it. I need to do it. It's that time. So Halloween is close in time. It's a couple of days away. So good. We've talked before, but I'm very anti-Halloween. I don't know if you know that.
I did not know that. I am pro Halloween.
So it's good to have both. We can get into that a little bit. I mean, for me,
why do you hate America so much?
It's the candy. It's the candy number one.
No.
Gosh, I feel, and I will stop short of my soapbox, but man, it's a drug, sugar. And
dude, I have no off switch when it comes to that kind of stuff.
Woo.
So I can't start. Once I start,
you're not alone. It's human nature. It is an absolute drug. But and those teachers just pop candy in those kids' mouth and send them home just full of sugar for us every day. And like, what is this? How can they be allowed to sugar at my kids? But then the Halloween is a full free for all. And then the whole, why are we scaring kids? What are we doing? Why are we scaring I got a 7-year-old boy. He's just scared to death of everything. And like, all right. What is this? Some hazing, some weird. I'm all for the Day of the Dead. I'm all for All Souls Day. But goodness, whatever. Yeah.
You want to know an interesting story I heard about Halloween this year?
Go ahead.
Okay, it's a quick one.
Yeah.
Apparently, you're going to see a lot less chocolate and chocolate candies this year because of a cocoa bean shortage.
Oh.
Due to drought in Africa.
Oh, no. Oh, interesting.
So you'll see a lot more gummies this year and a lot more chocolate, mashup.
Okay.
Stuff. So the cream-filled stuff, and they're trying to avoid using chocolate as much as they can because it's expensive.
Absolutely. And I mean, our kids, I've got two milk allergies in the house. And so I'm dairy sensitive. I think dairy sensitivity is sort of, I call it not sort of gaining popularity, but more prevalency. But I do remember my childhood. Those were the most treasured of all the chocolate bars, Snickers, Milky Way. Yeah. Oh, yeah. Trading my sister all the Skittles she would ever want, or all the Smarties. And, hey, let me just trade you for that Butterfinger, you know. So anyway, those poor kids, a little less chocolate this year. Sounds like. Yeah. Okay. Well, that's so you're pro Halloween. Do you enjoy decorating? And
I enjoy getting in the spirit, and it's still, it's a nice time of the year here in Minnesota generally. It's getting colder, but it's still sunny, and it's hunting season, which I love. And it's a lot of birthdays. And, it's a good time of year.
Excellent. Yeah. One final note on. I'm so anti-Halloween. We did carve, but we didn't do pumpkins. We carved watermelons, just to be outrageous and different. They're sitting out there. I tried saving some of it, but it was just a big blop at the end of it. It was a big stew of watermelon, so we ended up tossing it. But yeah, there are 5 watermelons sitting out front.
That is funny.
Just out there.
You got the whole family out there, man. You bring them with you.
Yeah. And you can carve them.
Now, was your dad anti-Halloween?
No, not necessarily.
A traumatic moment, or
I've just become
your encounter at a haunted house.
No, it's just been this. Well, I say a growing resentment for sugar. I'm super anti-sugar, and then this.
Well, I mean, I love sugar, but you don't get as good looking as you do by eating sugar.
Hey, thanks, man. I appreciate it. Yeah, pumping. I'm getting full energy. So, anyway, well, okay. Let's talk about some legal stuff. Inventors. I do have something else cool. It is mention related. You probably have heard this on our internal chat, but I've been producing music. Music. You didn't. Invention music. And so what better stage than this to live stream?
You gonna drop some beats? My first track.
So I'm a music producer. Those that are joining for the first time, real quick, I do an intro and we're 10 minutes late. Matt and I are attorneys. We're at Bold Patents Law Firm, and we're going to be talking, answering questions. If you have any questions, to have a couple live viewers on, pop a question in the box. We're happy to give you our information, some generic information, but we're not going to give legal advice. I will provide a link later for you to schedule a free discovery call to do that.
Okay. No interviews today. So
yeah. No interviews today. We have time.
We're playing jazz.
Absolutely. So I'm going to share. I have 3 tracks now, and it's been released. I'm using AI. You probably guessed. There's a platform called Suno AI, and so my process is the videos that I do some daily videos on top of this segment weekly. They're about 3 to 4 minutes long, talking about a subject, right? And this first one was a common myth that I hear and everyday people say is, I'm not an inventor. I'm just a regular person. I'm just out here in the world. And you might actually be an inventor. And that's what this song is about, is this, hey, anybody could be an inventor. Is this the time for you? And so what I do is I had a quick video. I took the transcript from Loom, uploaded that transcript to our ChatGPT model, got some lyrics, worked with them a little bit, uploaded those to Suno AI. I'm using the pro version where I'm paying for all the licenses for these.
We're going to get the world premiere right here.
We're going to get it. We're building up to it. And I put in you can put in what styles you want. And so I want something upbeat. So I put in, you may not like this stuff, EDM, electronic, disco music. I put in brass, because I like brass, a little funk.
Wow.
I used the word inspiring. So this was, and a few other things. I tweaked it.
So we're going to get some fusion.
You're going to get some fusion. And you can ask it to do male or female. I chose female for this first track. Let me share a screen and see if I can get audio for y'all. Here we go. Bold Patents. Audio.
AI, it's crazy.
It's a lot. Oh, I think I just put.
Man, we are working with so many clients on the AI side of things, whether it's patents or trademarks. My gosh, every client I talk to, we have to talk about AI and how that impacts their business.
1,000%.
All right, man.
You got 5. You ready to listen to it? Can you hear it?
Oh yeah, I'm ready. I'm dialed.
Here we go. Oh, that sounds terrible. We get a lot of feedback. Are you getting a lot of feedback?
Yeah, that didn't work.
It didn't work. And for that reason, I'm sorry, we cannot share it on our live broadcast. But I'm going to provide a link for each of you out there.
Well, why can't we share it in the live broadcast?
Well, it's just the audio is funky.
Oh, it was. I thought it was like some sort of security feature or something like that.
No. Let me see if I can change some things here.
You can't leave me hanging. I mean, I'm here this thing, JD. You got an audience.
Okay, we're back to the Yeti microphone.
On the edge of their seats. Pay for the full seat. Only need the edge.
Yeah, I know. And now I've got to sing it myself.
I'll do the.
You ready?
Yeah.
Oh, you're good.
Yeah.
That's not going to work. I don't think it's going to work. I think based on my inability, but that is the link. I'm not even going to say what it is because you got to be listening to the show to know what link that is.
Yeah.
0 live listeners.
There's no way we're spelling that out.
You got to actually listen. So check that out. Have a listen at you listening now? No.
Do you want me to?
I wish there was a way I could play it. There's gotta be.
I know. I'm pulling it up right now. I'm gonna put myself on mute. I'm gonna listen to it.
That sounds fantastic. We're gonna go on a little intermission. If you're out there, that link above, click link to listen to Bold Patent's #1 hit. World premiere. That's like is this the kind of music you normally listen to? Where are we at there?
I mean, dude, I love. So I'm like a music. I love music, right? And like I love like great music. But I'm also just a sucker for a good pop song too, right?
It's poppy.
I love me a good jam. This is a jam, dude.
Hey, all right.
You got a banger on your hands here.
Thank you.
Honestly, like it sounds really good. It sounds like it's kind of got that upbeat Sabrina Carpenter kind of vibe.
You nailed it.
Right?
Yes. Yep, it is.
Back 80s vibe, little synth. I'm into it, man.
Okay. Oh man.
Are you a musician by trade, by background?
No, I like music. I've always liked funky stuff. A lot of instruments. I've loved it, and I also like rap. This recent one, patents are expensive. Get some rap in there. Really cool. You can put in all kinds of stuff. I spent quite a bit of time. You can just have a lot of fun with the lyrics too. Anyway, it's a new content stream. Of course, we have this platform, our podcast. We convert into the book, the videos. But hey, if somebody out there is listening, and what it does, I use DistroKid is the name of the platform to distribute this music out to 33 or 35 different audio platforms. So that song you just heard, that did already get released. That one got released October 10th. And I've been doing releases every Friday.
Like this, I mean, the way you're naming this stuff too, like if someone like wants to find a song about inventorship, like they're gonna find this.
They might find, yeah. And these are it's the objections that is so common. What if I fail? What if I don't have time? Mm-hmm. Patents are expensive. And it's just like, okay, interesting. What's this guy talking about? And they're real questions. They're real concerns. And so it's fun. I'm having a lot of fun with it.
Yeah. Now, are you from 30,000 foot perspective? Are you one of these folks who thinks that AI is going to destroy the world, or are you thinking that it's going to be one of like the greatest, inventions in human history?
No, I think it's going to be a very wonderful thing. It is a wonderful thing. That's where I'm at. And I'm reading a really good book right now, which is helping me think through it. And it's talking about the difference between AI chatbots, which I think have become fully mainstream. Almost everyone is using has some experience with chatbots.
Yep.
Where it's prompt response. We're very comfortable with that. And what this book talks about is so fascinating, and I believe it's true, is it goes with this really cool example where I have actually done something similar. This guy was taking his family on a trip, planning a trip to Greece. And he's, I'm going to use AI, I'm going to use ChatGPT to plan it all out.
Yep.
Plans it all out, names all the locations, comes up with really cool ideas of where they should travel, pins it, gives them the names and numbers of all the hotels. And it's on him, actually, to go call and make the booking.
I just did this for Barbados next month.
Okay.
The exact same thing.
Really? And so this is common. This example.
Had a PowerPoint presentation made it. It was funny.
Now, what it goes through is it explains what's sort of happened here is this role reversal. We have actually become so used to, in a way, of using chatbots. Chatbots are now becoming the creative. They get to create and come up with ideas, whereas we actually are now the crunchers. We're the ones actually copying and pasting from ChatGPT. We're the ones calling and booking and doing the grunt work and finding out, oh, this resort closed a year ago. This isn't about, right?
Yeah.
So flipping it is very odd. Like we actually, as human beings, should be at least coming up with some ideas on our own.
Yeah.
And inventing and considering that, wow, okay, we need, instead of us being the crunchers, developing these agents. And that's the second phase of AI that you've probably heard of, is these AI agents.
Yeah. And that is where things get transformative.
Yes.
In my mind.
Yes. And this book talks about how there's lots of progress that's been made in robotic processing, like physical robots, alongside AI process. So once you can have those together, now you've got AI agents with robotic programming where they can actually physically perform tasks for you, and certainly digitally too, right? Booking a flight.
Yep.
And keeping in mind all the different schedules and doing what you would do. That's where the real value is, and we're far from reaching that point. But that's where the next step is, that is going to be exciting. The scary part, of course, is guardrails.
Yep.
Designing in guardrails, designing in, that classic, was it the paperclip example, where, the smartest of smartest AIs were like, hey, we're going to create this agent to go through a set of basically a logical process to create the most amount of paper clips it can and be as efficient as possible. And of course, the end state is it's going to take all the power of the world, killing the world and the power in the universe to make more paper clips, because that's all it's been given as its goal. Right? Yeah. So, obviously guardrails are needed, process guidance. So I think so long as we're able to figure that out, holding it back, if you will.
Yeah, in my experience, interacting with it, having our clients interact with it with us, my experience of it is mixed at this point. What it does do is create a ton of content. It's a content, right? It generates content quickly.
Yes,
but not all that content is valuable. Right. And a lot of the good stuff gets lost in the jargon and the ramblings. But I guess from my perspective, what I haven't seen AI do yet is increase efficiency through workflow optimization. I guess from my own perspective, I play with AI and I use those tools a lot, but they don't talk to each other. Right. And so there's no global AI user interface to kind of connect all these different things that we're doing, right, into a more holistic thing. Because, a lot of what I do on a day-to-day basis is, talk to client, enter notes, draft trademark, communicate with client. So there's a lot there that can be connected that isn't today. And we're so close. We are so close.
Yes. Yeah. I think it's this new role of AI manager, or you're basically managing a set of AI, and you're managing
Yeah.
the parameters, the inputs, the outputs, connecting AI, moving it forward to deliver a result. And to be a manager, you're going to have some knowledge of, be able to know if it's giving you BS or not. You're going to have some knowledge of the space to be able to check it and confirm, see whether there's any hallucinations, which can be challenging. So it's there, yes, it can eliminate mundane, repetitive stuff, and it can allow you to be more creative, less stressed out, hopefully,
Sure.
that type of thing. It's going to require some foundation in the subject matter. I don't think that's going to go away. I think you're going to have that foundation.
But I like that you said you're essentially a manager of AI.
Yes. Yeah.
I mean, I think that's probably where we're going with a lot of our work.
Yeah, I think so too. 100%. Yeah. And you got to consider it all. We're looking at things, like AI answering service. Do we do that, or do we keep what we know and love and having a human voice that knows us?
Yeah,
it's just hard to consider those things.
Yeah, and we don't have to. We can take a wait and see approach too. Which is kind of what I'm doing on my end. Is just sticking my toes in a little bit here and there, but trying not to break anything in the process.
Yep. Well, you're doing great work. You have great interaction, that human touch, that emotional touch. It's almost what it is, that emotional layer that's never going to exist in AI. It's that I understand. I get you. We've got experience. I know likelihoods of what's happening. I feel you, or feel where you're coming from. Let me just handle.
And those are all things that I as an attorney love. Is it? What I don't love is like filing trademarks, right? I mean, the paperwork. That's boring. But what I do like is getting on calls with clients and talking to them.
Yes.
And I feel like, on some level, as AI increases and our back end workload hopefully decreases, it just creates more incentive and more importance to have that relationship with the client, right? And spend more time there. Because a lot of times, I could be, calling the client up and just chatting with them and checking in, right? But we're probably looking at their docket, right? And seeing what's going on, calling via email. But more opportunities for connection are always important. And hopefully that's what AI gets us in the next couple of years.
Yeah. All right, Matt, you ready for some Q&A?
Yeah, let's do it.
Okay, well, these are stacking up. I'm just going to go right off the top of the pile. This is from our Reddit group. Thank you for those questions. Keep them coming. And thank you to Mia for gathering these for us. If I see one or two live people popping in and out, if you have any questions, put them in the comments here. We'll be here for at least a few more minutes, 10, 15, maybe 30 minutes. So feel free to put your question in. We'll get to you right away. Okay, this one's a little long, but I think we can fit it on the screen. Let's see. Okay, I have a business that I want to start, and I believe I found an awesome name and brand problem. Problem is, I found a trademark for the exact name, right, that dates back to 2013. Here's the catch. I've researched this company to a pretty large extent and cannot find their public use of the name anywhere. They're operating under a different name now. There's a massive coincidence. Their grace period for filing registration and maintenance documents for Section 8 and Section 9 literally just expired. Let's see if we can find the rest of it. Yeah. Well, I think
okay. Yeah, that's enough for me. I know where they're going with that.
Where are they going? What's up?
Yeah. So basically, clients got a name that they want to use. There's a third-party trademark registration that it looks like they've done some research and they're not using it anymore. And it's expiring, or it expired, because they didn't file a Section 8, Section 9 renewal.
Okay.
Yeah. Seems like it's available to me.
Nice.
Yeah. I mean, I would do some more due diligence, maybe talk to a trademark attorney who can, really dig in and see what's going on.
Yeah.
It sounds like you, like some of my other clients over the years, like have stumbled into a really great situation where you had this idea and the stars aligned, and this third-party registration that would have blocked you is no longer going to block you, and you're going to get the trademark through. So that seems like what this feels like.
It's fantastic.
Yeah, that's good news.
It is good news. So yeah, you can pick up where someone else left off.
Yeah, and obviously you can't, use their marketing materials as your proof of use or anything like that. But,
Sure. Yeah.
you can certainly. I was just talking to one of our new clients this morning, hopefully a new client this morning, and she's in a similar situation. Like, just quick background, like, was a founder of a company, left that company on good terms. That company ended up selling to a third party company who went bankrupt. And that company was has still been filing like renewals and extensions and things like that with the USPTO, and she wants to use the trademark again.
Yep. Okay. And
doesn't look like they're using it, and they're filing these renewals with a company that no longer exists. So the attorney's filing that. He should be looking at make sure that LLC is still in business. But anyways, client advised. Let's do it.
Fantastic. Here we go. Got a live question here. Thanks for submitting this. Hello, gentlemen. I'd like to know if you work with inventors from other countries outside the U.S. Yes, we do.
As long as you speak English.
Yeah, speak English. And also if you're trying to acquire a U.S. patent. Yes, those are kind of the two biggies. We are, and perhaps even beyond. So yeah, we have lots of clients outside the U.S. That are non-U.S. citizens, non-domiciled in the U.S.
Yeah, we help you.
Yep. So what I can do is provide a link. That's a good segue into putting my little link up there.
Now, do you is patent law in the United States similar to trademark in the sense that if you're not a U.S. citizen, you have to have U.S. counsel file your patent for you?
No, I don't think that's a rule.
Agent?
I don't think that's a rule. No, because foreign. Yeah, you probably do because say someone
like PCT.
Yeah, if you're doing a PCT, let's say you're from the EU, you will still at the national phase need a U.S. patent, at least agent, someone who's passed the patent bar to do any translation or not translation, but any type of adjustment to the app and get it submitted.
Yeah. That sounds right. I mean, on the trademark side, I mean, when we work with foreign clients, they're not U.S. citizens. They actually have to have a U.S. attorney, right?
Yeah. No, sorry, I'm going to take that back, Matt, because you can self-file. Was that your question? If you don't
have not a U.S. citizen,
I'm going to have to get back to you. I don't have that answer, but if you're U.S., you file in the U.S. My assumption is even if you're non-U.S., you can just file. But I don't know that. So good question. I'll leave that hanging. But that's the link there. ETA ETA 8. That's our number. That's our link for the weekly live discovery call if you have questions about learning more about our service at Bold. Good question, Matt. Let's go back to trademark side. I'll throw I did Reddit one last time.
Cool.
Similar one. Here we go. Wish you just kind of touched on this. I want to file for trademark protection, but want to know if it's easy for an individual to do it with no legal assistance. Recommendations?
Yeah. So it's been a few years since I learned how to file trademarks. But I do talk to clients who've gone and done it themselves. A lot of mixed feedback on it, right? Certainly clients are successful in applying for trademarks themselves. Successful in the sense of putting the application together potentially successfully. But we've had plenty of clients who, look at that application for 10 minutes and decide it's not for them and they don't want to do it. So depending on how much of a DIYer you are, you might want to look at it and see if it's something that you're willing to take on yourself. But if you have concerns about the branding, I recommend talking to a trademark attorney. It's easy for me, right? So if it's easy for me, it'll make it easy on you.
It's one of those things where it's easy but not simple to actually complete the application, but it's also easy to make mistakes and not get the registration you're after.
Yes, it is very easy to screw something up. I mean, something as simple as like the entity formation, like who's owning this thing, first use dates. Proof of use is the biggest one that I see trip up individual applicants. The proof of use, they submit incorrect stuff and they lose the trademarks as a result. So there's just a lot of little pitfalls that, are easy to trip up if you've never done one of these 1, 2, 3,000 times. And then, of course, too, just trying to figure out, what your product or service is and how you describe that in a way that's going to be acceptable to the USPTO. Over the years, you find ways of describing things that provide maximum protection while not, raising the hackles of the examining attorneys.
Yep. And is it similar on the trademark side where the examiners notably appreciate having an attorney?
Yes.
As opposed to the individual inventor or the applicant,
yes.
directly, right? So you have a big advantage.
Yeah, and I know most of the examining attorneys at this point in my career. So depending on who it is, they might just email me or they'll call me and ask for like an examiner's amendment. They're going to, if there's an issue with an application, the examiners are kind of incentivized to take care of it if they can right on the spot. So they will call the client, the individual person who filed the application, and let them know that there's a problem and this is how they want to correct it and get their permission to do it. But oftentimes those calls go unanswered. So it is nice for them to have an attorney of record they can email who's going to get back with them within a few business days typically.
Yeah. Sounds good. Thank you, Matt. Great answer. Let's head back to the patent world. This one is from Cora. Let's see here. I invented some sort of art tool. I'm an artistic research master's student, and now my mentors are pushing me to get a patent on it. I'm based in the Netherlands, non-US based.
Yep.
I don't have the money to pay for an attorney, but the invention is relatively simple. My question is, do you think in case of a very simple invention that are not complex to describe, could one do it without an attorney? Any advice on how to reduce attorney costs as a student? Can I ask them to just look at it? I don't know. Great questions. I like this a lot. Simple inventions are sometimes the most valuable.
Yeah.
And important to do right. And so while you may not have money yourself, if you've got the ability to hire a professional, I'll always recommend that. Yes, of course, I'm biased. Your question, to answer directly, can you do it on your own? Yes, you can file on your own if you're in the U.S. Again, that question you asked earlier is coming back to get me here. Can someone from the Netherlands file into the U.S. directly without an attorney? I don't know. I believe you could, but I don't recommend it. I think the patent law, it took me several years, after law school to study for the patent bar and sit for that exam. It's a separate bar. It's a manual. It's like a super thick manual, right? A lot of details in terms of what you need to do when the filings are correct, what needs to be required in that statement, disclosing lots of things. A lot of ways to get tripped up and make mistakes, have to go through a lot of education, spending time on something that you could otherwise spend on furthering your product.
For some context, trademark attorney here checking in, would never file a patent for myself, ever. Okay. Would not do it.
Yeah, right. Well,
I love taking stuff apart and putting it back together and figuring stuff out. Wouldn't do a patent application for me.
Yeah. I thank you. I think I appreciate that. I think it's without money, I see the perspective, and yes, we certainly do help inventors that have filed their own. You can file what's called a provisional patent application, and yes, it is less formal. It's a written specification where you just describe your invention as much detail as you can, making sure you explain the use and method, and then just putting pictures or written drawings if you've got them to support that. And that can get
a placeholder, right?
It's a placeholder, correct? Yeah, it does not bestow any rights, but it does have quite a bit of value. You have up to 1 year in the U.S. to then file a formal application, which has a lot more rigor to it and requires a certain format, and the drawings have to be done in the proper format. But the provisional can be a good, useful tool if you've done some research, you've tried to get money, you've tried to find ways to get grant money or friends, family, anywhere, other sources or credit.
That seems like the best for this person to go find someone who's got some money, right?
Yep.
And some time and interest.
There was another question in there that I want to get to is how do I reduce costs? And it's a great question. I think having your invention documented Okay, having something written down, having it clearly described in advance, getting that invention disclosure really clear. That's going to save a lot of time. And so if your attorney is charging by the hour, that'll help a lot. And if they're charging flat rate, there are times where if you bring in a fully baked, ready to go file invention disclosure, we'll give you some credit. Okay, so there's ways to reduce costs if you do some of the work on your own, or at least have the invention fully described.
Perfect.
All right. Well, let's see here. We got some time. We could keep doing Q&A unless you have any other ideas here.
No, I'm good with whatever. This is fun.
Okay. Well, let's do one more each, and then we'll look to kind of wrap up.
Sounds good.
We don't want to break a sweat.
Oh, there's plenty of trademarks waiting.
Plenty of stuff for you to do. Yeah. Okay.
Yeah, hundreds of emails to read.
I've got hundreds of questions here. How about you pick? I'll type in like a keyword. Give me a keyword, a trademark keyword. I'll look for it. Something you want to talk about. Put you on the spot.
Let's do intentional misspellings. Maybe type in misspellings.
Misspelling. Is that one word?
Yeah. I mean, trademarks. Yeah. How do you misspell?
Here we go. So this is
So this is one that clients constantly are asking me about. Is that I got this brand, and it's I do closets, closet design, right? And I call them Kathy's Closets, and it's cake, right?
Right.
And can I register that word closet? The answer is no.
Oh.
Generally speaking, the answer is no, because it sounds the same as the original spelling. So that might be described. That might be required to be disclaimed as part of the application process, meaning that word that you intentionally misspelled is actually descriptive. That's something that trips clients up occasionally. And then they can't seem to make sense of like why they can't register it, because there's another company that uses something similar to it, but it's registered, but it's it's spelled correctly. And yeah, so clients oftentimes think that they're being clever with intentional misspellings as a way to like brand something, but in reality, most of the time it's not a good idea.
Yeah, that's great. That's a cool topic. I guess we're thinking about the other side of infringement. Does that also an issue? Let's say there is a registration for Kathy's Closet, and here comes the next business with.
I was gonna say Kathy's Custom Closets, KKK, and then I was like, we can't do KKK.
No, let's do Kathy's, and so Kathy with Closet with a C has been around for 30 years, but I'm like, oh, you know what? I'm gonna open up my competitive business in the same line of business, doing design, closet design using Closet with a K. Is that going to avoid infringing Kathy's Closet?
It depends on whether or not the original filer was able to actually register it or not, based on 5 years continuous secondary use.
Yeah, let's assume that Kathy's Closet with a C has got the registration, has got it fully registered, has got it.
Yeah, no, you'd be infringing if you went to market with a K.
That's what I was saying. There you go. Okay, so misspellings.
I do see that quite a bit out in the wild, is that people play on other people's brands with intentional misspellings. It's trademark infringement. Same thing.
Yeah. And Walker, to take us one more step through that, let's get more academic. Why is that an infringement? I'm not using Closet with a C. Why am I infringing?
Yeah, the idea. So trademark. If you go back and really look at the purpose of trademark law, it's not necessarily to protect the inventor like this on the patent side, right? The public policy, or to promote the useful arts like it is for patents, right? On the trademark side, it's to protect consumers from confusion. So it's a consumer protection law, really. And so I guess what was your question there, JD? Sorry.
I think you nailed it. It's customer confusion. It is why it's infringing. Why using Kathy's?
And so the idea, that's it. So the idea then would be that these trademarks. I'm talking to you about Kathy's Custom Closets. I'm not differentiating. When I mention them between a K and a C, or whatever. So at the end of the day, they sound the same to the average consumer. in which case, we need to protect the consumer from this potential confusion in the marketplace.
Right.
And so the USPTO is the gatekeeper of that initial registration path.
And it's going to be, and what is that standard? Let's if we tried to abstract it a little bit more, Kathy's clothes closet, or just
let's do that. Kathy's clothes she sells clothing, right? And then there's Kathy's closets, and she sells closets, right? Are those two similar?
Right.
They might be. That might be. Those two might be too similar because their names are so similar. The idea of like how close trademarks can be to one another to all of a sudden create this likelihood of confusion, this mythical likelihood of confusion. It's not actual confusion; it's a likelihood. So more than 50% likely. So yeah, in order to do that, I mean, it's yeah. You basically have to look at the brands, right? Are they similar in sight, sound, and meaning? They sound somewhat similar, but do they mean the same thing? Not necessarily. They're related. Are they spelled the same? They're not. So you do kind of analysis of that, and then you look to see how close the goods or the services are. And then once you have that analysis, then you start looking at potential differentiators. Like, are these two products and services sold in the same channels? Are they relatively same price point? What kind of customers buying these? Are these like, sophisticated customers who, are in a niche market? I mean, there's a whole bunch of analysis that can go into it.
So if I got a lot of funding and I'm really excited to start Kathy's clothes, and Kathy's closets has been around for years. Why did we pick this example? It's fine. Would it make sense to just give Kathy's closets a call and be like, hey, I want to start a company called Kathy's Clothing. Will you allow it? Okay. So honestly, hey, right. Being upfront about it. Like, I want to compete with you. I think this is different. Are you cool with that? Is there
I've never had a client. I've never recommended we do that with any clients. Actually, that's not true. We did do that once with a client because they had a list of other names.
Oh, a big list.
This was their favorite, but there were there was two other ones that if they couldn't get this one, they could definitely get these other two.
Okay.
And so we ended up contacting the third party, and they kind of hemmed and hawed about it. So we ended up going with the second option. But in a case like that, where as an attorney, I wouldn't want to ruffle any feathers and kind of let them know that we think there's probably an issue here, right? Because me calling them is, hey, that's a likelihood of confusion issue potentially, right? I found you. I'm calling you. Let's talk.
But maybe you find that point where it's like, oh, I've got a different name, and I just want to get them to. Maybe can you pay for it? I pay $1 to have them waive the ability to sue for infringement on a name, that kind of thing.
You can purchase a consent agreement, a coexistence agreement. I mean, we
some of that, probably more than $1, but yeah. Right.
Yeah.
Okay. That's cool. Yeah. Very good. Thank you, Matt. All right. Well, let's do one more on the patent side, and we'll wrap up. That was good. Kathy's custom closets. Okay. Last chance for anybody out there listening or watching. You can put in your question there. Yeah, this goes on and on. I didn't actually mark which ones we've done before, which is not great. Let's see here. Come on. We got patents. Here we go. This one could be a bit of a repeat, maybe not. So I'm in the early prototype stage of an invention. And I'm working on, and I found an existing active patent for a product that solves the same problem as mine. I'm not well versed enough to tell if they're different enough to continue to pursue. What do IP lawyers charge just to tell you if your design is safe to explore? Cool. Good question.
What's the magic number?
For us, $2,500.
Yeah. Okay. Yeah.
And that is, we'll give you the answer. We'll give you our opinion, our written opinion on this is patentable.
Cool.
So that's actually about an infringement question, right? They're asking, hey, I've got found an existing patent. I want to know, am I infringing? And usually it's about that per patent. Sometimes clients will come and say, hey, I'm worried about these 7 patents. I'm like, well, that's going to cost you.
And I know there's a technical name for that opinion. It's called
freedom to operate. Thank you, Matt. If you ask us, hey, if I go to market, am I going to be sued meritoriously by the patent owner for this patent? We can answer that. That is called a limited freedom to operate opinion. And I use the word limited because there certainly could be other patents that you may not even know about that are maybe infringing whatever you're selling.
Why would a client be interested in a freedom to operate opinion? What are some examples of like situations where they're going to like be required to go get one?
Absolutely. Thank you. So let's say you have invented a new coffee cup lid. Okay. You've got a brand new way that the magnet attaches to the slider, and you're going to go crush your competitor Yeti. Okay. You got to bring your Kathy's custom cup.
Let's get them.
Okay? We're going to go get them. You've got this lid that's out of sight. There's a little injector to put a little bit of that, that bee sting, so you get the puffed lips look. The women out there. The women love a little bit of a Botox lip while you're drinking coffee.
Wow.
But you want to sell it with a cup, and you want to make sure you're not going to be infringing companies like Yeti. You like the double wall, you like this small, compact look, but you're not quite sure. You want to know that the cup, the whole mug with lid, your innovative lid, the whole thing, whether you're going to be infringing anyone else's designs or utility patents around the whole product that you're selling. Quite often, that's the case where inventors have, come up with something fantastic, but they can't actually sell just what they patented.
Right.
Part of a larger system product.
Have you ever worked with like clients who've been required to get these types of freedom to operate agreements, basically to like cover, CYA, the manufacturer or the retailer? Like the retailer wants some cover that says
not a whole lot. No, we haven't, and that's likely coming. I think if we're at some point going to represent larger companies that are smart enough to ask those questions. That's really honestly what we're at. Our clients are fairly early stage, almost all of them, where they don't have manufacturers lined up yet. A lot of them are pre-manufacturing, pre-revenue, pre-production, but those questions are coming for a lot of our clients as they begin to grow. And liability, and their investors, attorneys are asking questions. They're starting to worry about, hey, what's our risk? But you bet they should be asking that question. The problem is for so many of these bootstrapped inventors, it's too expensive of a question to ask. Yeah.
I mean,
am I ever going to be liable for infringing? Yeah, probably. and it stinks. The fact is that if they do go like gangbusters and sell 1 million of those items, they're going to get hit. And it's just one of those things that, you wish you would have, could have, but it's hard to know everything. The Donald Rumsfeld or whoever.
We have a couple of those clients who have been really successful, pretty well known, right? And they get the nuisance lawsuits all the time.
Yes. Yep.
You're infringing my collar, for a product, just random stuff like that. It's just nuisance money.
Yeah. Yeah. So the right answer is, the perfect answer, I suppose, is as you're moving forward in the market, staying in contact with your patent attorney, and at the right time when you've got just enough funding, asking those questions as you're growing, not to stay, head in the sand on just building your tech. Stay in touch with your patent attorney, ask those questions about liability, ask those infringement questions as you go, and you'll be in as good a place as you can be. Right? You're never going to have all the information up front. It's not going to happen. You're not going to be able to build a product. You won't be able to get off the ground. It's like, if you want an airplane to be as safe as possible, the airplane would never take off. You're never going to have the ability to reach the sky without some level of risk. So that's it, Matt. Blasting off to the future.
Love it.
A little bit of risk is tolerated.
Yep.
We wish all our listeners a wonderful week. We're going to be back next week after our Halloween little vacation or holiday coming up.
Yeah, stay away from that candy, right?
You
want to be my accountability partner?
Yeah, I do. I would joke with my kids and half joking. about doing a trick, right? People ask trick or treat. I'm going to give you a trick.
Yeah.
What is that trick going to be? Have you ever pulled that off? What would you do? Their faces, I'm sure, would be just shocked as they hold their pail out. I know you said trick or treat. I'm going to give you a trick. Let me tell you a little bit of something about sugar, or something horrible. I mean, some yo-yo. I don't know what I'll do. Hand out broccoli, veggie straws, something horrible. But we'll figure it out, Matt.
All right. Right. Well, go get them.
Thank you. See you guys. Matt, everybody have a good weekend. Go big, go bold.
Go big, go bold at boldip.com.